Get my folder. There it is.
And we're live, Mr. Secretary.
All right, thanks. Good morning, everybody. Good morning, members of the Juvenile Justice Reform Council and those that are watching us streaming live. I want to welcome everyone to our meeting. And, I think we've done introductions before, and I think actually one of the big advantages of doing these Zoom meetings is everybody's got a name in front of their face on the computer, so we can all see who everybody is. We have what appears to be a pretty small agenda, but I think it's some pretty meaty topics that might take some time to get through. One thing that you might notice that's not on the agenda is probation. At our last meeting, I indicated that we were going to try to put the under 13 or the minimum or the lower end age jurisdiction issue on, as well as probation. Excuse me. However, we were not able to get all of the analysis done for probation. So we want to move that to the next meeting and have that discussion at the next meeting. Also, after sort of working through some of the issues, we have the survey results to review as well and setting priorities. I think it would be a bit difficult to get to two substantive issues and have any meaningful discussion on them. So without further ado, I want to go ahead and go to the minutes. I believe those were sent out ahead of the meeting. And if folks haven't reviewed them, please take a moment to review them, and I'll entertain a motion to approve those when you're ready.
I would make a motion to approve them.
Thank you. Any seconds?
I'll second.
Okay. Any discussion? Unless there are any objections, please voice your objections. If I hear no objections, we'll consider them approved. Hearing none, we'll go ahead and go forward and move to the discussion on under 13 data. We're going to have Dr. Selena Cuevas and Marta Nelson, newly minted PhD Selena, to present these. And congratulations, Selena. And I'm going to kick it over to you and Marta.
Thank you so much for that introduction. Let me just share my screen. Oh, I mission to share my screen.
Jamie, can we give Selena permission to share her screen?
Just 1 second. Let me enable that.
No problem.
I was commenting earlier that everybody's really gotten used to using Zoom, and it's so easy now. We don't have to do all the technical stuff, but I guess we still have a few little bumps to work with.
It should be up.
Oh yeah, perfect. All right, can everyone see that? Okay. Okay. So my name is Selena Cuevas. I am a research consultant with the Vera Institute. I will be the one doing the analyses to supplement the conversations we're having each council meeting. Today, as we're talking about minimum age of jurisdiction, presenting on demographic and geographic characteristics, charges, and court outcomes for youth under the age of 13 in Maryland. All right, so to start, the data set that I was analyzing included all DJS intakes fiscal year 2019, 18,899 intakes total. Within this sample, those that were 13 and older accounted for 90% of the sample, while those under the age of 13 accounted for 10% of the sample. And so the first thing I wanted to do was explore the demographic composition of the under 13 subset, but also compare it to the sample as a whole. And what I found was for those under the age of 13, these young people that are coming into contact with the system have a higher likelihood of being Black and a higher likelihood of being girls. And Black girls in particular, while they account for 18% of all intakes, they account for about a quarter of intakes for youth under the age of 18. Next, I explored geographic differences, cases, and what I found was that Anne Arundel and Baltimore County were the counties with the most cases for young people under the age of 13, accounting for about 30% of all cases. At the regional level, Eastern Shore and Southern regions accounted for over half of cases for young people under the age of 13. And so I wanted to see how this mapped on the percentage of cases that these regions account for overall to see if, they were similar. And what data showed was that Eastern Shore and Southern accounted for a higher proportion of cases for young people under the age of 13 than they do for all cases, whereas places like Metro, Baltimore City, and Central account for a lower percentage of cases for young people under the age of 13 than for all cases. As for the charges that these young people are coming in on, so together, person-to-person and property misdemeanors account for over 80% of all charges that young people under the age of 13 are coming in on. In comparison, for the full sample, person-to-person and property misdemeanors account for about 63% of all charges. Misdemeanor assault in particular, a person-to-person misdemeanor accounts for half of all charges within this age group in comparison to the full sample where misdemeanor assault accounts for less than a third, about 30%. Next, looking at crimes of violence, so the most serious charge category. This category accounted for less than 10% of charges, 8.8% in comparison to a slightly higher 11% when looking at the sample. And the most prevalent crimes of violence charges were for felony burglary and break-in, robbery, felony assault, and felony sex offense, which together accounted for 95% of all charges in this category. Next, I explored case processing and looking at processing overall. We wanted to explore how many cases are dismissed or withdrawn at some point. So resolved at intake or informal, and then dismissed or withdrawn as disposition. What the data showed was that 81% of cases do not result in a formal petition, and of the 19% that are left, 9% result in formal petition but are subsequently dismissed or withdrawn. This is not a perfect measure because this excludes cases that are still pending disposition, but it's just a way of looking at it overall, the big picture. Here within case forwarding decisions, I explored all cases, so regardless of whether they were pending disposition or had disposition. And what I found for case forwarding decisions was that cases for young people under the age of 13 are less likely to result in a formal petition. So 24% in comparison to 39% for the full sample, whereas cases for these young people under the age of 13 are more likely to be enrolled or resolved. Next, we were interested in exploring whether racial disparities exist and are more pronounced for these young people. And what we found was that racial disparities in forwarding decisions exist at all age, but they're actually less pronounced for young people under the age of 13. So Black youth at the age of 13, 25% of cases result in formal petition in comparison to 20% of white youth in the same age group. But you see that these disparities are much larger for the sample overall. For 43% of Black youth overall, their cases result in formal petition in comparison to 28% for white youth. Here we are only comparing Black and white youth because of the fact that other racial and ethnic categories accounted for much smaller proportions, so much smaller numbers to be comparing. Next, in exploring dispositions after formal petition. So young people under the age of 13, their cases that result in formal petition are much less likely to result in a disposition of commitment. So 3% in comparison to 12% for the sample overall. While dismissal rates are similar for these young people in comparison to the full sample, their cases are also more likely to be withdrawn or denied. And finally, I wanted to explore commitments that are happening for young people of this age group. And what I found was that for youth under the age of 13, there were 11 total commitments during the 2019 fiscal year. 5 of these commitments were for crimes of violence, so 2 felon sex offenses, 1 robbery, 1 carjacking, and 1 child abuse case resulted in a commitment. But there were also 6 additional commitments that were for person or property misdemeanors. So 3 misdemeanors, 2 thefts, and 1 handgun violation. And so, especially for the crimes of violence cases, I wanted to see if any of these cases were quote unquote unique to the data where they resulted in this disposition. And what I found was that these charges were not unique. Their cases were mostly handled in other ways. So for example, robbery, while it accounted for 1 commitment, it also accounted for 15 dismissals or cases withdrawn, 12 cases resulting in probation, and 3 step dispositions for these young people under the age of 13. The only case that was unique in its disposition was handgun violation. While there were 3 handgun violations for this age group in the 2019 year, only 1 had a final disposition. The remaining 2 still had a pending disposition. Does anybody have any questions? Yes.
Scott, go ahead, please.
I already violated my no talking rule. So I'm really interested in the slide where juvenile services dismissed 81% of those under 13. Would you mind going to that one? Can you do that? Or
Yeah.
it was near the beginning. Yep. So I don't know if this is possible. So just tell me if it is. Is there any way to look at that 81% and see how many of those folks we see again when they're 14, 15, 16, or 17? Because I'm really kind of interested in that. You know, should we be offering those individual services?
So I do want to say that what that 81% represents is that cases did not result in a formal petition. That doesn't mean they didn't receive services.
Okay.
We can use pre-court supervision and diversion services in that area. But I do think we could look at, and I'll defer to my data folks, but I believe that we could take that group and run, you know, a like recidivism analysis or something on that subset to see if there were new offenses or, you know, the rates at, you know, for that subset. Is that what you're looking for?
No, actually, I just wanted to make sure they were being offered services. So we might want to fix that slide a little bit because we don't want people to think that that they're just walking back out the door. If they're being offered services, then I'm very satisfied.
Okay, yeah, we'll take a look. So yeah, some of them may have been resolved at intake, which means they didn't have to do anything else other than meet with the intake worker and come up with an arrangement. So typically, if it's like sort of a theft case of a small amount and we can, you know, do restitution right there, we can resolve those cases. For others, there may be some that were given services. So yeah, we'll I think we can get a breakdown of that, of who got services and who was resolved, and get that a little bit more detail on that 81%.
If you're 12 and you shoplifted from Walmart, you know, I'm not saying what you got to do, and it doesn't have to be a big deal. And that's why I'm not bothered by, you know, including the burglary or breaking in, because I mean, some of those could be sheds. Obviously, it's the other crimes of violence that I kind of am more concerned about. But thank you very much.
All right, other questions?
Yeah, I think that you may have just answered it, but what I'm interested in is is there an inquiry into all cases, before it's disposed of, even if it's diversion or even if it's just dismissed or there's no formal petition? Is there always an inquiry to determine or ascertain whether and what services are needed in all situations, whatever you decide to do?
Yeah, I'm going to ask Betsy to give a little more detail on that answer, but the answer is yes. And Betsy, could you just go over briefly how the intake process works and how those kids would be handled?
Yes. So when we receive a complaint, whether it's from a citizen or school or law enforcement, we need to schedule an intake conference with the young person and their family and review the complaint. And we also do an assessment that helps assess their risk for reoffending, as well as their needs that they may have related to the offense or to any treatment that we can provide. And then we do some service matching. We take those needs, the needs sort of are highlighted, and then we have a service, the community service map that helps us match the young person to services that were identified to best meet their needs. That's sort of our pre-court supervision. And then we'll make sure those young people and their families are connected to the services. If we resolve a case and we don't do that sort of pre-court supervision period, that means we sort of just close it. But that doesn't mean we don't make a service referral. Given the circumstances of the young person and the family and their needs, or if there were other interventions already provided, we may close the case, but still provide sort of a connection to a community-based organization that can help them. The pre-court supervision is where we really sort of follow that young person for 3 months. And we do have a report on our website that I'm sure we can send out to you all that did evaluate the outcome and performance measures for our pre-court supervision. And just briefly and generally, I will say, while young people are on pre-court supervision, 96% of the young people do not have any new adjudicated offenses. And then if we follow them 1 year out, 90% of the young people who are involved in pre-court supervision do not have any new adjudicated offenses. But we can get you more information about the performance outcomes.
So once there's an assessment and it's determined that services are needed and there's specific services that they're directed to, are services readily available, or is there a wait period where you might decide this program is right for this child, but there's a wait list or there's no openings and then the child has to wait for the services? Or are they always accessible and available at the time of the need?
That does fluctuate. Generally, we don't have any wait lists getting into programs. And what we have done at the department over the past year, we have taken all sort of our services and programs that we would use at the back end of the system. For example, if a young person was adjudicated delinquent and then put on probation, and then we may say, oh, here's an evidence-based services like MST, multi-systemic therapy, and we connect them to that. We've taken all those programs and put them at the front end of the system. So now any young person who comes right in that front door, if an evidence-based service is appropriate, if like the choice program is appropriate, YAP, we've really expanded the continuum so that we can make sure we're matching the young person with the right service and that we're not waiting for a lengthy court process to be able to connect them to something that may be exactly what they need.
And Senator Carter, I just add one other thing, as our populations have declined significantly in the last few months. And as a result, all of our providers and programs, their censuses are very low. So there's virtually no wait anywhere right now, but it can fluctuate. So, I don't want to say that it's never going to be a problem, but at the time it's not.
I have a question whenever there's time.
Yes, Ms. Egan, please, your question.
Thank you so much. So I was looking at the breakdown of charges slide, which I believe is your slide 4, as well as this information or presentation about the impact, given that the vast majority of these charges are dismissed or found that there's no jurisdiction and that most of them don't proceed to court. Are we going to receive any information or presentation about the impact of an arrest on a young person and the collateral consequences of those arrests. Because it seems to me if 80% of charges are being dismissed, then we should really think about whether or not we should be putting these very young children in handcuffs and cages. And then my second question is looking at where the charges are coming from, and that the majority of them seem to be person-to-person misdemeanors. If anecdotally we know where the referral source is for those counties or jurisdictions that are referring more young people, in that in anecdotal experience, those person-to-person misdemeanors tend to be school fights, right? That these are low-level school fights happening. And I was wondering if we look at the referrals, if we can break down further the referral source and who is channeling these young kids into the system.
So on the impact of arrest data, I will defer to Marta or Selena if you have literature that you may be able to share. I know you may not have it right now, but something that we could come back to and give some information on. The second part of your question on the sources, I think that might be somewhat muddled and somewhat difficult, but this might be a small enough population where we could possibly tease it out. But I need to consult with our data folks. I think a lot of times, school-based offenses get classified as police offenses because school police may do the arrest. And so I do have some issues there may be some issues with that data. But it might be a small enough group that we might be able to disaggregate that down a little more finely. So we'll have to come back on that and make a note of it.
Yeah, and I'll note that on the question of the impact on arrest, I don't have specific data on that, but in the presentation I'll be giving after this, certainly the issue about sort of collateral consequences of children that young and going through the system, which starts with an arrest, will be something that's discussed in terms of, sort of psychological literature on that. But there isn't, certainly for this sample, there's no follow-up. And I'll just note this is a 2019 sample. So even sort of the question about, what happens to those kids whose cases are dismissed in terms of further recidivism, we wouldn't be able to, DJS wouldn't be able to do that with this sample because it's a very recent sample.
I sort of wanted to, I don't know, tag team with Jenny's comment. I mean, the school stuff I think is really important. And if you look at data from BJS, so the school crime supplement, or just general victimization data, the reports of low-level assaults are actually highest at kind of that middle school age group. So I was also interested, do you have just a general age distribution for the whole of it? I mean, we've been talking about the under 13, but what, I think first the question should be, what is the appropriate, break point? Is there a natural, change in the distribution of overall of cases coming in? But then to understand these person-to-person misdemeanors, which, I mean, Jenny was saying school fights. I mean, it could be just pushing in the hallway, which, if two adults walk down the street and some adult pushes another adult into a wall, yeah, that's an assault. But kids at that age, their personal space boundaries are not set yet, and that's common behavior. I was also curious if you know anything about the kids' backgrounds in terms of child welfare involvement. The couple small number of sex offenses, were those in family or otherwise? Because I think knowing, there's just like a million questions that I have about this population. But we had one point had done a report looking at the sort of court careers of kids that are very young like this, under 13, and I can share that with the committee later.
So in terms of a breakdown of all, I'm sorry, go ahead, Marta.
Selena does have that breakdown by age.
Yeah, so just from this first slide. So kids under the age of 13 account for only 10%, but then you break it down, I have it within kids under the age of 13. You see that the percentage of the distribution that kids account for gets bigger as kids get older. And then I presume that you would see the same thing, including all, but here I only broke down kids under the age of 13, but they do account for overall 10% of the full sample.
Yeah, it would be great to just see that distribution overall, because I think, again, I don't live in Maryland, but understanding what the school grouping age groups are, are the 13-year-olds still in middle school? Are the 14-year-olds mostly in like a 9th grade high school situation? That having, if we're talking about changing the minimum age, having it align with other significant ages may make sense. And it may not be 13 as the cut point.
We do, Melissa, have the breakdown of all the charges. We can get that. That's, I think, in our data resource guide, and we can get that pretty readily. In terms of, why did we select under 13? So it's sort of sometimes confusing. Under 13 really means 12 and under is another way to say it. I have to sort of go back in time and try to remember what was the really driving force around it. But I do recall some literature some years ago suggesting that, there was a significant difference at that point, 12 and under. And so we started collecting data on it. And so the reason that Selena and Marta are presenting it as under 13 is because we have a data set that is, a number of years old, and we have a pretty good track of those kids, and we've been tracking them separately for some time. If it's efficacious to look at a different, number, and I think Marta has some additional information about other states' experiences and where they've set that, and that might sort of get to what you're asking about when she does her part of this presentation.
Excellent.
Secretary, I have a question. Good morning, everyone. I just want to, it's very surprising to me that the majority of the data that we're looking at is girls, is females. But I have a question as to what as the intake process go on, how is that intake person identifying the causes or the root causes of the situation? Like if we're saying that we have an intake person, are they, do they have any doctorate degrees for social work or anything like that? Like how do they know to identify those causes?
So I'm going to give it back to Betsy. No, they're not necessarily PhDs doing intake, but we do use a structured tool that has been developed by some PhDs to help guide our decision making at that point. Betsy, do you want to elaborate any?
I'll just add that we do use a structured tool to identify what the needs are, some of those root causes, so that we can identify them and then connect to services that would, be great interventions to hopefully support the young person and their family. Our case managers by law have to have a 4-year college degree. They do get substantial training. But as the secretary mentioned, our tool that we use at intake has been validated by the University of Maryland Innovations Institute. Our tool that we were using prior to the validation is included in the DRG from last year, but we have made revisions since the validation, and that will be included in our new DRG, but we can provide that to this group so you have it to take a look at. It goes over risk and needs, but also walks the intake worker through more of a structured decision-making process to really go even a little deeper than just risk and needs, but also to really check in and say, okay, well, if this was a school incident, maybe the school already intervened and we can check in on that intervention and see if it's appropriate, because we don't want to layer on a lot of services when something is already provided that's working. But we'll get that tool to you all to take a look at.
Betsy, can I just ask the question? There's lots of conversation about services and what services are necessary. What we know or what the literature tells us, I just wanted to know if DJS had a position about whether every child who commits a delinquent act or may be arrested is in need of services.
No, we do have a position
No.
on that, and we don't need services for everybody. And as I mentioned in the beginning, there are a lot of cases that we resolve at intake, which means we can, have a conversation, and resolve whatever the issue is. I use the restitution example because it's an easy example, but you're absolutely right. There are a number of kids, and we talk about this, and I think we do gloss over it sometimes, that are exhibiting normal behavior. There's no treatment need for someone that's acting normally. They just happen to be an adolescent, and that behavior that might be normal for them also is something that we want to teach them not to do, and we need to move them away from it. But not everybody gets referred to services, and there are a number of kids that just don't need anything. And I think it is an important point to make when we bring kids into services, however we do it. There is risk there as well if they don't need those services. And, we always try to keep that in mind. We don't want to do harm. We want to make sure that if we're getting someone into services, it's something that they need, and it's something that's tailored to their situation. And we do recognize there are a number of kids that only need a conversation and they can move on. And a lot of those kids do just fine too.
And I'll just add, we want to be really intentional about not layering services in when there's already a connection to a community-based organization or something through the school or some other support that is really meeting the need. We don't need to layer on lots and lots of things just in the name of saying we referred someone to something. We want to make sure it's intentional and it's productive and it's appropriate and it meets the young person's needs.
Okay, I don't want to stop any other questions, but I will just say that there is a little bit more to this presentation. But if there are other questions at this point, we will take those. And if not, we'll continue the presentation. I think, Selena, you may have a couple other slides, and then Marta has some feedback from other states, or at least one other state that has implemented a floor on juvenile court jurisdiction.
So I included additional slides in case anyone had any questions relating to that. But these slides, so the first one was exploring serious charges and outcomes by age, especially how many of the more serious charges we see by age. While it increases by age, it's also important to remember that just the cases overall as kids get older. But what you also see is in terms of case forwarding, that for these more serious offenses, a larger percentage result in formal petitions as young people get older, but that overall these most serious charges don't account for the majority of formal petitions. It ranges between 19 and 40%, and that dispositions vary, which is what we saw with commitment being a low percentage of dispositions. And then the last slide was just on dispositions for specifically these more serious offenses, where you see commitment is slightly higher at 5%, but still very low. And you also see 39% of these cases get dismissed. Those were my additional slides.
Can I ask whether or not we looked at how many of these children had competency raised and what percentage of these children were found not to be competent?
I did not have on that in my data set, so that wasn't something I was able to explore. I don't know if anyone.
But I think, Jenny, we could probably look into that from the DJS side and provide some information for those petitions that were formal and how many had a competency filed, and then how many or what percentage of the young people were found not competent. not able to obtain competency, we can probably break it out.
Okay, any other questions before Marta goes? All right, Marta, you're up.
Okay. Me too. Ah. All right. Okay, are you seeing my screen? I think so.
Hi.
Okay, so we've seen the data on children under 13 in Maryland. I wanted to share what's happening nationally around the question about raising the age of jurisdiction. So this is literally taking some aged children out of the juvenile justice system altogether and responding to whatever issue may be happening with them through Department of Social Services or school-based services, so that the child is therefore not arrested and not brought into the system. And this is a movement that is starting to happen in a number of different states. So right now, some states have a minimum age of jurisdiction, some don't. Maryland is one of 27 states that do not set a minimum age of jurisdiction. You'll see Utah is gray in this one, but it just set an age this year, so this map didn't have a chance to catch up. But there are 27 states that do not have a minimum age. Recently, Utah this year raised the age of jurisdiction to 12, with some exceptions. You see them there. They're the sort of the most serious felony offenses. In 2018, Massachusetts raised its age to 12 with no exceptions, no crimes accepted. In 2018, same year, California raised this age to 12 with limited exceptions, essentially murder and rape, and one or two other, the most serious felonies. And in 2016, Nebraska raised its age to 11 with no exceptions. And then this year, the Connecticut Juvenile Justice Policy and Oversight Committee, a committee that looks very similar to our council here, issued a report in January of this year recommending raising their age to 12 with no exceptions. And then the pandemic hit, so there's been no action on that recommendation in terms of introduced legislation. So this issue has been studied recently in a number of different states to sort of make the case for why to remove these cases from jurisdiction at all. And here are the different arguments that have been put forward. First is neuroscience. Essentially, I mean, there's been a lot of talking about how older adolescents don't yet have sort of their prefrontal cortexes developed and have more impulsive decision making. But for preteens, they are basically neurologically immature in terms of ability to just make rational decisions, much less sort of more impulsivity that you see with older children. So their level of decision making is even lower for what we're calling preteens. So that would be, below the age of 12 or 13. Legal competence, and this is to what Jenny was saying about competency to be in a setting. Children have diminished ability to understand that they're in a legal system, that they have charges against them, that they have rights, that they're in an adversarial system, the role of adults in the system. I mean, they're used to listening to adults telling them what to do, and which makes their ability to then interact with adults and make up their own minds about what's best for them very compromised. So the next part that's been raised is another point that was raised, is the harmful effects of being in the juvenile justice experience system for a child as young as this. Many children might have some adverse childhood experiences as well. And so now they're in the juvenile justice system, there's arrest, there's the processing, even if the cases are dismissed, that can lead to poor outcomes in terms of trauma, mental health issues, and also just a continued distrust of the system, be it the juvenile justice system and perhaps the criminal justice system later. Other collateral consequences are just what happens when a kid is going through the system at that age. They're missing school, there's disruption to the family. Another point that's been made is that this is a poor use of resources because so many of these cases do end up being dismissed. As you saw, the stats in Maryland were 90% between, most of them are pre-petition, and then some are dismissed or withdrawn after petition. It's about 90%. The study that was done in California found that about 96% of cases did not have a disposition for kids under the age of 12 in that state. So, so the question then becomes, why are we going through this process when most of children these age are not going to end up with a disposition? And then the last argument that's been made is about sort of the international standards. The United States Convention on the Rights of the Child set the minimum age of court jurisdiction, juvenile jurisdiction at age 12. But if you look at what's happening in developed countries, it's usually about age 14 is the most common age. So through this example, those are the reasons that other states have used to essentially launch a campaign to change the age. Just wanted to put one more bit of information about one state that has done this, which is Massachusetts did this in 2018. So on Monday, I had the chance to speak with their Commissioner of Department of Juvenile Services, so Sam's counterpart there in Massachusetts. And it was a very interesting conversation. As you can imagine, this was passed in 2018. It was part of a legislative package around criminal justice reform that had many facets. They were having a conversation at the time about raising their age of to be tried as an adult above 18, and that is a continuing effort in that state. That was not successful in 2018, and as part of the sort of the conversation in the legislature, they decided they wanted to do something on this, and that gave impetus to creating a floor. If they weren't going to create ceiling, they decided to create a floor. So the commissioner said that the implementation has been absolutely smooth. There's been no issues whatsoever. That again, there weren't that many children of a young age in the system, as in this system there are not that many kids that fit into that category, and that there haven't been any issues. I mean, the main question really becomes for a child who does having a school fight or having some sort of behavior that's inappropriate. What do you do with that child if that child is not arrested and brought into the system and perhaps getting services, as we've heard is available here in Maryland through DJS in the pre-petition stage? And it's pretty well acknowledged that there do need to be services for kids who need services. So the question is, where do they get them and what's the mechanism? In Massachusetts, they have what they call the family resource centers that are in the communities. Massachusetts got rid of its child in need of supervision statute. So that is part of that. They created these family resource centers that are available for children to get services on a voluntary basis with their families. There would also be the ability, if there were a case where the child really seemed to have some sort of a psychological or mental health need, to attempt to get that child services through a petition through the mental health system. So these are sort of non-juvenile justice, certainly not criminal justice, ways to get young people services who need them. And that was also in the California legislation, and it's part of changing that age. There was part of that legislation that required there to be provision of services outside of the juvenile justice system for kids of those ages. So that's sort of where things are nationally. Obviously, the question of what Maryland will do, or as it considers this issue, is up to this council to decide if it wants to make a recommendation or not. But it's always good to be informed by what's happening in the rest of the country.
All right. Thank you, Marta. And of course, we want to have an opportunity for everyone to ask Marta questions. But I do want to just talk a little bit about, since this is our first policy discussion about sort of the process, what I'd like to do today is we have our conversation. I know there have been some questions, and we will try to maybe email those questions or those responses back if they are critical to forming a recommendation. But following this conversation, what we'd like for everybody to do is consider submitting their recommendations for what the policy should be, and submitting those in the interim between this meeting and the next, so that we can tee those up for voting, hopefully at the next meeting. If we need more conversation, we may need to hold off on voting on something, but as much as possible, we'd like to have the conversation now and then have folks bring their recommendations for votes. So with that, I want to open it up for questions. And I just ask folks, if you have a question, unmute and ask your question, because I can't see everybody even on my expanded view. So if you have a question, please just go ahead and unmute and ask it. And if it gets a little too hairy, we'll go back to the recognition piece. Any questions?
Hey, it's Scott. So I just want to make sure your bullet that says poor use of resources, most cases for children under 13 are dismissed. We're still using the word dismissed like we were with the 81%, where it doesn't mean those kids aren't getting services. It just means that the case is not going forward. So, I mean, I think that's a little misleading, because it makes it seem like we're not offering these children anything, but we are. I mean, that's what Sam and Betsy just told us. And I like the idea that you described in the Massachusetts situation, but then we would have to create a whole nother system to take the place of what Sam and Betsy run right now. I'm just trying to get a sense of why we do that, particularly one, these records are confidential and I can't even use them when they become an adult. So that's what I'm just trying to figure out.
So I will start to address that, but I would imagine, there'll be some more informed conversation from Maryland. I mean, I think the difference is that, yes, people in Maryland and in other places who are arrested and brought into the system may get services in the pre-petition stage, but there is sort of some of the bullets here about the harmful effects of the experience, the collateral consequences of the experience. Those kids are still in a juvenile justice system, which the argument is that is a harmful experience for a child of that age, particularly if the child is behaving in a normal way for an adolescent. It's just being, reacted to through an arrest. And so if there's a way, if indeed services are responsible, and I think are needed, and I think the point has been made throughout that, sometimes services aren't necessary because this is normal behavior, to provide those services outside of the system without sort of the stigma of arrest or the stigma of going through that, even if indeed the case ends up being dismissed, that the process in itself is not a good one for a child of that age.
Yeah, Marta, I think that is I'm sorry, Heather, I'm going to get to you. I just want to add one thing to Marta's response. And I think in other states where they have set these floors, it's a different response. So they still have responses, but their response should be from a different system. Like the social services system is typically the one that would respond to younger kids. And that is, in fact, if we had if we're talking about, let's say, a 5-year-old where there's no question about they shouldn't be in a juvenile justice system, that's where they would go. And so it would be extending those services from the social services system would be one avenue. And that is a common avenue I think states have taken when they're looking at setting floors like this and saying, well, which system should be the appropriate system to respond? And that is the conversation, I think. So Heather, you had a question or a comment?
Oh, just a comment. It seems to me that looking at what other states are doing, that we wouldn't be, I think to exactly what you said, Secretary, that we wouldn't be creating an entirely different system, but kind of basically reinvesting resources in some systems that are already there. So kind of more on the front end. So again, education. So investing more resources in education, kind of some of those community-based resources that can support our young people getting those services kind of where they are. So it looks like, based on the data that we saw here, that sometimes some of the cases are being sent back. They're not going thoroughly through the system. And so instead of even going there and spending more resources, then we don't even have to go there, but we can just make sure that families are getting the supports that they need more informally. And then when in looking at other states' data, even with the coalition, so I've been connected with the Coalition for Juvenile Justice, and there are a number of states in the coalition that have shared similar data. And when you look at their recidivism data, it looks incredible. And because they're putting this money up front instead of kind of essentially, I don't want to say wasting money, but essentially that's what you're doing, is kind of wasting money when you're going through all of these actions when you don't really need to, when you can just kind of put in supports earlier on, know exactly kind of what they need.
Secretary, if I may, just wanted to add in for everyone to take a look at maybe, but we do have local care teams in every jurisdiction around the state, and local care teams include representatives from DJS and the Department of Social Services, schools, and families can self-refer to local care teams, and they also do an assessment, and then they can provide or connect young people and families to services in their communities. Oftentimes when you see DJS resolve a case, meaning we don't do anything when the complaint is brought to our attention, we are making a referral to a local care team where families can speak with all the representatives from a multidisciplinary approach to connect the services in their communities. So we do have that structure within Maryland.
So my question, Marta or Betsy, Marta first, in Massachusetts, where they've abolished their child in need of supervision statute, which I'm interested in, but I guess I'm curious because where they have the family resources centers as an alternative, so to speak, of what would normally have been the juvenile justice system, how does that work? So a fight in school, for example, the principal would then call the family resource center, or as Betsy described, a member of a care team to come in and do an assessment. Or, child throws a rock through a window, rather than the police coming, would then some resource from this care team or family resource center come? I mean, how do you get from an act to the services? What's the connecting point?
Right. I mean, I think it's a great question. I think it's a cultural change. So since there is no juvenile justice or criminal justice system for children 11 and younger in Massachusetts, the care team is not like comes in on request. It would be the principal would have the situation in front of them. These kids are fighting. The principal would then probably call the parents, and then the parents could and tell the parents, there's this family resource center, but it's something that the parents voluntarily use in order to deal with the situation. There could still certainly be school discipline. It's not that there isn't a school discipline process that could be as robust as that process, assuming this happens in school. But it's just something that the justice system it doesn't become a justice system issue. It becomes a school disciplinary issue. It becomes something that involves the parents. It becomes something, and the family resource centers are there to be for the parents to use or the school to use to connect a child to services. And if the situation were severe enough where you have a child who is exhibiting, terrible psychotic behavior or something, which would be very, very rare, then you could, use the mental health system to petition for some sort of services or treatment through that. Which again would be a very unusual circumstance, but basically it would be not for kids who are in Massachusetts at being 11 and younger, to just not be thinking in terms of a justice system for behavior for those children. It would be other resources.
And this has been in place since, did you say since 2018?
2018. Yeah.
So do you think there's any data on outcomes available?
I can certainly ask. I mean, I think that there, again, were very, very few cases of kids coming in under that age into the system to begin with.
Right.
So it hasn't been really noticed. I know that it was, the secretary at least there said that was a bipartisan thing. It was seen as not a heavy lift. Again, always politics matters. This was in the context of which there was a political fight over sort of the higher age. And this was seen as something that was not controversial, perhaps compared to the other issue. But I can ask certainly to see what's been going on. I mean, the case that he has said there has been no, the worst case that you would think of, which would be something terrible happening involving a young child. That has not happened since 2018.
If I could jump in a little bit here, we've done work looking at how states handle what we would call status offense behavior and things that are often under CHIN's legislation, parts of the code. And, Massachusetts and Pennsylvania, Vermont fall into a category where those cases are, those behaviors are really handled much more as dependency cases rather than juvenile justice delinquency cases. There is sort of a spectrum, and Maryland right now falls kind of right in the middle under that children in need of services category. But there is variability across the country in how that whole range of things, is couched and how those kids are handled. So just the way you now would handle that 5-year-old, that you're just pushing that to you're raising the bar, the age for those things. And I would very much caution to always use the phrase raising the lower age, because you don't want the discussion to be confused with raising the upper age that transitioned to the adult criminal court system. That was Massachusetts' big fight. This seemed like totally a piece of cake when they did it.
Secretary Green, you had a comment?
A question, and this is for me. I'll use the word. This is deflection, completely away from any footprint in any system, is what you're describing. It's family service. It's deflection from any type of, I would say, it's a structurally formal system like DGS or other things. So my question then would be around, with that deflection opportunity, the opportunity for parent, guardian, individual to provide a list of these services or resources. What do we know? Is there a priority in those resources yet in Massachusetts or other states that have said this seems to work the best? This is what you call it, in terms of not stigmatizing it for a parent that is fearful of their seeking that service and then having their child be noted as beginning to enter this system. What are those services? What do they call them? How do they make sure people know of them?
So Marta, before you respond, I just want to reframe this a little bit and bring back something that Ms. Egan said, which is a lot of these kids really don't need necessarily services when we're talking about something. And I think that one of the earlier slides showed, or I think maybe it was Dr. Sickman saying that a lot of these are adolescents or in middle school having fights. And I think that, Marty, you mentioned changing the culture, and that's right. What we would need to really look at is, all right, if we have kids that are fighting in schools, why aren't we using like community conferencing at school to deal with that school issue? We ought not engage the criminal justice system. And I think that's really the conversation, is that the criminal justice system isn't the appropriate place for very young children to go into that are experiencing those behavior issues.
Right. So when I'm thinking of service, I'm thinking about just family family education, family counseling. How do you deal with understanding what adolescent behavior looks like, and how to help your children through them? So I appreciate what you just said, Secretary of Ed. It's not a service, but it's an opportunity, a resource in that change of culture. But do we know what some of these resources are, and how they're reaching the people that they need to reach in Massachusetts? What medium are they using?
And what do you do when they say no, when the family says no, on top of Rob's question?
Right. Well, I will begin, but I think Melissa might have a better sense of that. I mean, my understanding from what my conversation with the Secretary of Juvenile Services in Massachusetts is that these are voluntary services. They're in every community. They were created as part of the switch from the child in need of supervision system. But again, it could be, using existing services from the Department of Family Services, what we would think of as the child welfare system, or school systems. But they are voluntary. And I think where we're sort of have to wrap our heads around is sort of to what Melissa says, the way you would treat a 5-year-old. Like, you wouldn't be like, why aren't we, bringing in, it's just sort of this understanding of expanding our notion of who are children, and thinking about what's the appropriate way to handle a problem with the child, it being school-based, and creating school-based resources or family-based resources. But the short answer is that these, the services are voluntary services. Again, this is, unless in the rare instances where you're talking about some sort of a mental health commitment, which would be an entirely separate system. But these are voluntary services that the family can get involved in. And then in the school system, it would be whatever a school disciplinary system is that doesn't involve bringing in the.
I'm very supportive. I'm very supportive of this notion and this culture. And as Secretary of Ed has talked about, absolutely. I just think even the notion of calling it services, how do we reframe and reimagine? Services to many have a negative connotation, shouldn't, but that's a reality, and I think in the culture. And so I'm just wondering how they've, again, even framed those resources to families.
Right.
Yeah, I think that's a good way to sort of put the end on this. We ought not.
Could I ask
a question? Senator West, please go forward.
Sorry, I've been lurking here. So my question relates to the 9% of the kids who commit crimes of violence. And let's just take a hypothetical. Some kid, 11-year-old, been playing a lot of violent video games, gets a hold somehow of a gun, and takes it to school and shoots the person who he regards as his enemy. What if we went to a system in which the criminal justice system simply didn't handle kids under 12? How would we deal with that?
I think that's a good question, and there are a number of different options. And if we look at some of the options, and I know in some of the other Martoni or other slides you showed, there were states that made exceptions for certain types of offenses. So that is a potential way to move forward. But there are many ways that we can deal with that issue. But typically when I see somebody 11 years old or 10 years old, even if they've committed or they've been accused of committing a crime of violence, there is always something underlying that. It's not that they're some kind of hardened criminal. They just don't have that kind of capacity at such a young age, and that we really need to get to what's underlying that issue. And oftentimes we see family issues or mental health issues that need to be addressed. And again, I think we can look at that and say, is it appropriate to address those mental health issues in the criminal justice system, or should we address mental health issues in the mental health system? So there can be a multi-system response. It doesn't have to be just, oh, well, we can't do anything. there are other avenues, and I think we can explore how we deal with some of these, sort of rare cases. But there are options, and I think we have some of them up here, and maybe we can come up with others. Marta, did you have anything? Or I'm sorry, Senator West, go ahead.
I was going to say, so long as Scott Schellenberger is on the phone, Scott, does your office ever deal with violent actions committed by kids under 12? And do you think that it would be better not to have those kids who commit violent offenses ever darken the door of your doorstep, but rather be handled by other organizations?
So I would say our numbers are very similar to what the statistics are showing, and that is we don't really see these folks, these young people that much. I can tell you that the next time a police officer in my jurisdiction arrests a 5 or 6 year old, they're going to get a call from me because it's ridiculous. So, but the place where I'm concerned is what you're talking about, and that's the 11 and 12-year-old who are capable of doing some violent act. And my problem is, again, what I just said, and that is, what is our option if the family says no? Sam, I understand maybe there are underlying mental health issues, but you know how hard it would be to get a kid committed to a mental health facility who's 11 or 12 on a SINA petition. There just needs to be another option that forces the family to deal with the issues. Now, if Sam wants to take all these great services he has and give them to another agency, he's still going to need them for the ones who are 13 and up. So I just don't know how we're going to create this whole other system, and when we don't have other options. That's what I'm concerned about, Chris.
And I appreciate that, and I think that there are ways that we can overcome that. When we talk about the services that we use, a lot of the services that we're talking about are services that are also available within the social services agencies, and we do have a lot of overlap. When you look at our committed placements, the vast majority of the placements that we use are actually licensed by the Department of Human Services, not by us. And so we utilize a lot of those social services type of responses because we get so many kids that really fit that system. And so one thing that we do have is a crossover youth practice model that we've been rolling out across the state. And, it's been interrupted by COVID, but where we have those established connections, we can work those cases together with Department of Social Services and see that a lot of them really do belong there and manage it. And maybe that's one way we can deal with it. But I think that we can come up with options for those outliers. There are ways to deal with the outliers. I think that when we're talking about a floor, and the thing that really gets me upset about this is that we don't have a floor. And whatever that floor may be, it's very difficult for me when I, think about this, that if you're an 8-year-old, you could be legally put into my system. If you're a 9-year-old, you could be put into my system. And that is, that's an uncomfortable place to be. And that shouldn't be an option. Where we draw that line and how we do that, I think is the difficult part. We have some options, and I'm certainly open to hearing everybody's opinions, but I think there are other ways to handle this and to handle folks that don't want to, take those services. And I would just say that I don't think that it's appropriate to incarcerate an 11-year-old because he or his family wouldn't, agree to do a program or something to that level. And I'm not saying that that's what you're advocating for. My only point is when we bring them into the juvenile justice system, that becomes a possibility. And obviously the data suggests that prosecutors and judges don't want to do that because very few of them actually get there, but some do. And so I think we just need to come up with options. And I think it's fine to raise those issues because those small number of cases do exist, and we can come up with solutions for them. I believe that we can.
Sam, I would love to look at the file of the 11-year-old in the state of Maryland who's been incarcerated. Just show me one.
Right.
We can show you one in Pennsylvania.
I can show you one in Baltimore. So I just wanted to interject briefly with 4 points. First, to Senator West's example of a crime of violence for a very young person. What I think Secretary Abed pointed out so well is that the services that they get from DJS are very akin to those that they would get in the CINA realm and in that world. My question is, why would we criminalize them, and what would the effect be if they go? What is the effect when those young people do go into the DJS system? When that 8, 9, and 10-year-old are incarcerated, does that make it worse or better? And what lots of the research shows is that when you treat them in the criminal justice system, it can do more harm and make those behaviors worse rather than better. Dealing with them in other systems isn't just effective in terms of like what we think is right, but actually may have better outcomes for those young people. To that end, I also was concerned in that the slides that we looked at talked about the case forwarding decisions by race, but it didn't show how many kids and kids of color are coming into the system. Kids under 13%, 65% are Black. And so the young people who are facing these arrests, it is racially discriminatory, and it is about racism, about who is coming in that front door. So I wanted to raise those two things. The third being the history of charging kids this young. There used to be a floor in Maryland. We used to follow the common law, and that there was a presumption of infancy for children under the age of 14. That existed in statute until 1994, when in the big crime bill, the presumption of infancy was taken from children in Maryland. So I also want to say that this is not some inevitability. This is not how it has always been. Prior to 1994, we treated kids under the age of 14 differently. And I want to look at that historically and talk about the reasons that we stopped treating kids that way, and who we think of as young enough and innocent enough to be in need of assistance, as opposed to labeling them delinquent. And it is clear that this has extreme racial components and is racist against young Black kids. And I just want to make sure we're explicit about that, and that the changes that were made to charging kids and putting them in the delinquency system have been recent in Maryland's history, and we can fix those errors.
This is Pauline Mandel from Maryland Crime Victims. I've been listening to this conversation, and I will tell you that I'm involved now with a juvenile case of a 10-year-old who murdered a 1-year-old. So a lot of the issues that you are talking about, are difficult. My perspective is I have a mother who lost her son, and at this point in time is totally frustrated because it doesn't seem like there has been any kind of solution to anything, and this has been going on for about 1.5 years. So I think, there are a lot of questions, but, I don't know the answers to them at this point, but I do know that when we're talking about serious crimes, even if we're talking about younger children who have committed them, that there are victims out there and people out there who, would like to understand or know what's going to happen. Our office was involved with, I think, 2 or 3 homicide cases this year that were committed by not young children. My client's the youngest at 10, but I'm sorry, not my client. The child who's involved in that one was 10 years old. We had another one who was, I believe he was 15. So, and those were both homicides. So they do happen. So that's all I wanted to say.
Any other questions or comments?
Well, could I come back to my original hypo? So
Yes.
After all this conversation, I still haven't gotten what I think is a good answer as to, assuming we were to adopt the 12-year-old cutoff, if an 11-year-old committed a violent crime, what systems are in place now which would deal with individual and ensure that that individual did not, in some way was changed, and so that the individual would not engage in another crime. Certainly another crime of violence. What would be the alternative that's in place right now?
So as I think I may have said this, and maybe I glossed over it, Senator, but as the screen shows, there are other options. So if the concern is about an 11-year-old or about a particular type of, very high level crime, we could look at Utah, or we could look at California and say, okay, they've looked at things and made exceptions. Obviously states like Nebraska and Massachusetts decided not to do that. But when, as I mentioned, and we don't know the circumstances of individual cases, and a 10-year-old though that commits a violent act like that, I think we really need to have the mental health system involved more than anybody else. Now, again, these are discussions that we need to have, and we can take recommendations. We don't have all the answers for everything, but I think what the general direction is here, that we should have a floor. We should have some floor, and if there should be exceptions, we can talk about those exceptions.
Sam, with respect, I think the idea of exceptions makes some sense. But assuming, I suspect one of the recommendations that we would have to vote on would be to simply go to 12 with no exceptions. So my question is, if that's the recommendation that is accepted by the committee, what would happen to an 11-year-old who did what the advocate for the victims of crime just suggested, murdered a 1-year-old? What systems are in place right now in Maryland which would deal with that situation if we did not have the criminal justice system or the juvenile justice system as an alternative?
So we do have systems in place. I'm going to ask Betsy to give a more specific answer on how we would respond to that. Obviously, we have this case, so maybe we can, if anybody has knowledge of it, we can talk a little bit about it. But there are, obviously, if somebody is charged, we don't have a minimum age. So all of the responses that the Department of Juvenile Services currently has would be available right now.
So if we did say there was a cutoff, and your hypothetical, the child welfare system is a system that's designed to intervene with children who are in need of assistance, and the children in need of assistance, can be a very big category of young people, whether they're neglected, abused, or have some significant underlying conditions. You also have the behavioral health system in Maryland that can intervene with young people. There can be emergency petitions filed with the court for young people at any age to require emergency psychiatric evaluations. You also have the core service agencies and local jurisdictions. You have local care teams in local jurisdictions that bring together all the resources from the state agencies to intervene and provide voluntary services. So that would be the sort of, continuum that would be available if there was an act like that and there was not juvenile or criminal jurisdiction.
Well, I'm sorry, if I could just say, I think a couple of things that are frustrating to me. My background is I worked for legal aid and represented Senate children for 15 years before I came to Maryland crime victims. So I have a lot of knowledge of the system. And, from the beginning, this child needed services. And the issue was she ended up in Waxter because there was nowhere else to put her. And apparently, I was told, she didn't receive any kind of services.
I'm going to object to the discussion of an open case and court records that are confidential and are not to be disclosed publicly.
Okay.
Yeah, thank you, Jenny. I think we could probably figure out who the young person is given circumstances and connections, so we need to be really careful.
Okay, I apologize. All right. I
This
won't
is
say anything more.
I don't mean to interrupt anybody, but I think it's really relevant at this point. We keep talking about the DJS system, and I know that's what our goal is here, to make these recommendations. However, I think that Jenny touched on it, and I know Betsy and Sam have touched on it. The fact is that there are already systems in place in Maryland that can treat children. If education and human services and child welfare and mental health would not look at DJS as like, okay, that's a kid who did this, so that's DJS's issue. The fact is, this should be an interagency kind of thing we're looking at. And it would address the questions that Senator West has asked, and that some of the other folks, including Jenny and us at the Juvenile Justice State Advisory Board. We really feel as though this is an interagency thing. And if they they create a floor, then all those agencies, schools who see children every day or should see children every day, human services and child welfare who are in these homes occasionally or maybe more than occasionally, anybody who touches that child and that family should have a stake in saying, what can we do for this child and this family before they say, oh, DJS. So I am a strong proponent of looking at this very carefully and reminding us that in Maryland, we have had a long history of interagency collaboration around children, youth, and families. It isn't there anymore, at least not in the structure it used to be. But the fact is, we need to really consider that we need to go back to that, and that DJS should not be the fallback, nor should they be expected to fix all these programs when we have lots and lots of dollars and lots of expertise that are in all these other areas that impact a youth who either does or doesn't do the kinds of things we've talked about today.
All right. Thank you for your comments, Rosemary and others. At this time, if I'm not hearing any other questions or comments, I would like to turn it over to Anton to go over the survey results.
Okay, hi everyone, and I'm going to share my screen. So at the last meeting, we talked a lot about some of the priorities and work that we wanted to do. Of course, we manage expectations given that December is fast approaching. And so I use that as framing to sort of say that if some of the issues that we discussed or some of the issues that you wanted to see referenced are not in the top 5, still there's a lot of overlapping of the issues as our conversation today has shown. And so I imagine there will absolutely be an opportunity to sort of raise them. Okay, so we had almost complete participation. There were about 38 returned responses surveys. And accordingly, I want to highlight the top 5. So here's the list for the top 5 priorities. The way that we did this is we analyzed in each category. So everyone had an opportunity to rank their priority. There were 10 referenced. You were told to select 5 and then to rank those 5. And so what we did was we analyzed the ones that received the most votes and then analyzed the average for those votes. So for the people who voted for them, how important were those issues? And so we got to services being the #1 issue that people wanted to discuss, ensuring that youth who are in the community have real quality services. The second priority for everyone was detention and commitment reduction. All right, so we saw that we have sort of changed policies in reference to commitment, and we want to keep that energy going. And then diversion was the third top priority, so increasing opportunities to divert youth. Education, we talked a lot about that today. And again, I see that as one of those overlapping issues, expanding and improving vocational and non-traditional high school educational options for youth. And then we also had out of home and out of community placements as the fifth priority, reducing youth out of home placements and out of community placements. So those were, out of the 10 options that we gave everyone, those were the 5 that everyone lifted up as priorities for us to sort of talk about through December. Of course, there are opportunities to do more work, and certainly that may need to be done. And there's opportunities to discuss the convergence of the issues. So I'll leave it there and turn it over to the Secretary for New Business unless there are any questions about the priorities.
All right, any questions about the top 5? All right, Anton, thank you for presenting that. And I think
one question.
Nate,
sorry.
I'm sorry. Thank you.
No, that's okay. It just struck me in the survey itself that the second and fifth ones on here, I know we talk about overlap, but they seemed especially similar in terms of what we're talking about. I mean, I get that one is specifically maybe about releases and the other is about reducing the population, but they seem like number 2 is a lot of within number 5. So I'm just curious about it as distinct areas. And I don't, if we're really limiting ourselves to 5 things because we can only focus on 5 things, this felt more like 4 to me. And so I'm just curious when it's on the list. I don't know, maybe just articulating what would be different about the 2. Is the second one a subset of the 5th one, or are they really distinct, and what that should mean for the group?
Mr. Secretary?
What would number 6 have been?
We have a question. I'd like to let Anton respond before the next question. Go ahead, Anton.
Okay, so what I'll do is I'll put up I'm going to share my screen, a different screen. But yeah, so I see them, to your point, as issues that could be addressed separately, and they were ones that were sort of raised distinctly in the last meeting. That was sort of why we separated those issues. But to the extent that the council wishes to do something else that may be possible, I think that the issue to keep in mind is really that there will be a further discussion of all of those issues. All of those issues are very important to the youth justice system in Maryland, and so they will be a part of that discussion. But this is simply what we agreed upon at the last meeting.
Yeah.
So I'm sorry, I could probably give you a little more nuance, Nate, with the detention and commitment reduction piece that's listed here. I think that's looking at some of the responses. That's looking specifically at our responses to COVID. And when I say our, I'm looking at everybody's response, including the court's response. And so that's sort of looking at that Court of Appeals decision or administrative order, and looking at some of the things that DJS initiated along with our stakeholders, and we've done as policies. Some of those policies may be considered for legislation. Some of the aspects of that court order may be considered for legislation to cement those. And then on the last one, the out of home, it says out of community, but I think we sort of more commonly call it out of state placement. And that's sort of more of a traditional issue that we've had here in Maryland. So it's looking at generally, taking kids out of home, and then the issue, I think, out of state placements and how we can correct that. I'm sorry, Marta, go ahead.
Yeah, no, I think you said it exactly right, Secretary. I think of the second one as being sort of the particular about, is there a way to memorialize the actions taken in response to COVID, and particularly with the courts administrative order. And the fifth is more sort of, like New York State's close to home initiative would be an example of, a policy that requires children who are placed to be placed close to home, and to, shift the commitment of children from faraway locations to close to home locations, and to sort of think hard about whether children need to be leaving the home at all. And so there's a series of different, which Nate, policies out there that have done that. And one that comes to mind, because I'm a New Yorker, is the Closer to Home initiative in New York.
I think there was another comment somebody had.
Yeah, I do. Well, first I want to say that I'm troubled that jurisdiction is not among the priorities, because I actually think jurisdiction of the juvenile system is a priority. We just spent the beginning of this meeting talking about jurisdiction at the low end, and that plus the issue of juveniles charged as adults. I don't see how we have a robust and comprehensive reform plan without including that. And so I would move that we do find a way to combine 2 and 5, and that we include a discussion as a priority of juvenile court jurisdiction.
I'd second that.
I third that, and I would note that I think 1 and 3 are also very closely aligned and could be addressed together in terms of services and designing services for diversion.
Okay, well, thanks for the third, but we have a motion and a second. And so let's have some discussion about, and I believe the motion was to include juvenile court jurisdiction into our list of priorities. And I didn't catch the last part, Senator Carter, but I did get the juvenile court priorities. And then, so let's start with that. We have a motion and a second. Is there any discussion about the motion to include juvenile court jurisdiction?
And we find out where it was on the priority list. I mean, is it last?
Anton, do you have that information?
Absolutely.
And before you answer, I also wanted to just mention that we talked about the lower end of juvenile court jurisdiction. And the reason that it's not on your top 5 is because we've already made it an item. So that, and then probation, we wanted to do a look at probation practices as well. So these are the top 5 of what's remaining after those 2, which we had already agreed to do. So we do have a piece of juvenile court jurisdiction, but it's the lower end. And so your motion would be looking at the upper end of that. So any discussion?
So Anton, do you want to walk through what this is?
Sure. Mm-hmm. Okay, so you'll see here the list of priorities that we have. The top 5, here's the top 5. And then you'll see that rounding out the bottom 5 starts with redefining delinquent act. Then we have adult court jurisdiction, youth charged as adults, there we go. And then youth leadership, creating a youth leadership advisory council, and then data collection. So that's your top, that's all of the 10 priorities that were referenced in the survey.
Well, it seems to me that 7 and 8 go together, adult court jurisdiction and youth charged as adults. And to me, it's just very troubling that we would begin to believe we could have a discussion about reform when all over this country, there are movements afoot because of the greater understanding over the last decade or so that children are children and brain science, and the fact that that children should not automatically be treated as adults. And the fact that we have that automated system, it has to be part of this discussion.
All right, any other comments or discussion on the motion?
Well, I know I think Senator Carter is so spot on that I think we would look very frankly just out of place in what's happening around the country, where people are exploring this very question. And the fact that we have this council that is so rooted in looking at the research and the adolescent brain science and doing what works, and the trying young people as adults has been something that we know has such bad outcomes that we wouldn't explore it as part of this council. I agree. I think would be a huge missed opportunity. And I think it's core to what we're being asked to do, which is really to look at how do we have the right responses that are best for young people and best for residents of Maryland.
Could someone tell me how to interpret this document we're looking at? Like category 1 is 16 and then in parentheses 2.88. What does that mean?
Sure. So that means that 16 people rank that as a priority. So one of the top 5 priorities. And then
what's 2.88?
2.88 is referencing the priority level within those people who voted for it. So the highest being 1, meaning 1 would be the highest priority you could give, and then 5 in this case would be the lowest. So that's why.
So I'm looking at number 7, which in parentheses says 3.11, which looks to be, well, no, actually it's not the highest, the one below that. Well, it's confusing. You would think that 2.88 would be the highest number, but it's not. The ones down near the bottom are higher than 2.88.
Right. When 1 is the most higher priority, then you're looking for a smaller number means more interest.
Yeah, so the 2.88, Senator, is referring to, that would be the average ranking. So there were 16 people that ranked that first priority in their top 5, and 2.88 of those, 2.88 is the average score. So it was closer to 1 than it was to 5.
Right.
In terms of prioritizing, 1 being your highest priority. So it's sort of like a golf score. The lower score is the best score, if you will, on that in the brackets.
All right, thanks.
Well, I think if we vote, it should be through like a survey monkey or something, because if we just raise our hands now, it's going to be all too confusing. And everybody's not on the web.
To be honest with you, I think that there's so much overlap with 7 and 8. I'm not even sure if that's an accurate count. If they were combined, would it still be a 9, or would it be a higher number? Because there could be people who didn't, did with one and not the other. We don't know. Anyway, it's an important issue, and we'd be remiss if we didn't deal with that issue.
Yeah, and thank you, Senator Carter. Scott, I think that we have a proper motion and a second. And so I would like to do a roll call vote on the motion that we have before us. And so, Jamie, are you on? Jamie Lancaster?
I am. Hold on, let me, I can get the materials to do a roll call vote. Hold on just a moment.
Okay.
And just a point of clarification, are we voting the way Senator Carter stated, I think was almost like a collapsed of the 6 and 7 on the 7 and 8 on the list here?
Thought it was 2 and 5.
Well, no, her motion was about adding jurisdiction as a topic.
No, I think and Senator Carter, please correct me, but your motion was to collapse the 2 and 5 together and add in adult court, youth charged as adults or jurisdiction as the 5th priority or as another priority on the list.
You're right, Betsy. But I was also saying that I think 7 and 8, as if we add that as a topic, it's one topic.
And I'll help you, Senator. I agree. It is one topic.
Mr. Chairman,
Yes.
hi, this is Luke Clippinger. My question is, you saying it's a priority. This would be one of the issues that we would continue to address between now and December.
That's correct. Yes. By making it a priority, that means we would put it on the list of items that Vera would research and then come back and give us a presentation about.
This would not be, it's not like we're voting for a recommendation today.
Exactly right, Mr. Chairman. That's right. We're just voting to prioritize this and get more information about it.
Thank you.
Okay, Mr. Chairman, I think I'm ready here.
Okay, Jamie, did you have a chance to write down what Betsy said on the motion, which is to collapse those two items and add the additional item?
So if you could just go over that again, which two items are we collapsing?
So Anton, if you could move back to the original page that listed the priorities, there were two items that were overlapping or that seemed to be the same. So just so we make sure we get the right items. And it was the detention and commit reduction item and the out of home and out of community placement items. I think the motion was to collapse those into one item and add another item or another priority, which would be examining juvenile court jurisdiction.
Okay, so the motion is to collapse those two items and create an additional item to examine juvenile court jurisdiction. I'll go down the roll call of the roster, and if everybody could give me their vote, yay or nay, I'll keep the record. Senator Carter?
Sorry, I keep turning it off. Yes.
Senator West?
Yes.
Delegate Clippinger?
Yes, to continue the discussion.
So I'll mark that as a pass.
I voted yes.
Oh, yes, okay. Delegate Jackson? I don't believe we have Delegate Jackson in the room. Delegate Pippy? And I don't see Delegate Pippy in the room. Secretary Green?
Yes.
Ms. Tolentino?
Yes.
Mr. Kammerer?
Yes.
Ms. Egan?
Yes.
Judge Stam?
Judge, you're on mute.
Can you hear me now?
We
All
got
right.
you, Judge.
Being a member of the judiciary, I'm going to have to abstain since it's a policy question type thing.
Dr. Gilbolt? I'm not seeing him in the room. Dr. Lawson,
Yes.
Dr. Sickmond,
Yes.
Mr. Bayless,
Yes.
I don't believe, is Commissioner Harrison in the room with us?
He is not. Deputy Commissioner Sullivan's on for Commissioner Harrison. Yes.
Mr. Chair, I hate to interrupt, but I don't think we've gone over this, but since the commissioner isn't actually present at the meeting, did you want to allow a substitute vote?
His designee can vote. I think that's fine.
Okay.
So, Mr. Sullivan, do you want to vote?
Yes.
Yes, yes.
Mr. Schellenberger,
I'm trying to decide whether to vote my heart or give all of you a heart attack. But I will vote my heart, no. But you don't have to keep counting.
Mark does a no. Ms. Davis, I don't see Ms. Davis in the room. Ms. Mandel,
Yes.
Mr. Dodson, I don't see Mr. Dodson in the room. Ms. Handy, I did see Ms. Handy earlier. She may not be in the room any longer. Mr. Campbell,
Yes.
Ms. Chapman,
Yes.
Mr. Fonseca,
Yes.
I saw Mr. Fonseca. He keeps dropping in and out of the meeting.
I believe I heard him vote yes.
Technical issues. I'm sorry?
I believe I heard him vote yes.
Yes,
It was just
okay.
faint. Yeah.
Mr. Houston,
Yes.
Ms. Johnston,
Yes.
Mr. Ford,
Yes.
and Mr. McGlone. And I do not see Mr. McGlone in the room. So
Have we missed anybody that's on the call? I don't think we have.
Secretary of Ed.
Oh, I'll vote yes as well.
Two, three. We have 18 in the affirmative and 1 in the negative.
Okay, we will consider that passed. We now have a new list of priorities. We will ask our team to, Anton, if you could rewrite them and send those out, obviously ahead of the next meeting, but as soon as after this meeting as possible, so everybody can have a chance to review those with time. So the motion passes. And with that, I'm going to ask Marta if we have any remaining items for next steps.
Hi, sorry, this is Lynn. I'm on the call. I vote yes.
Okay, there you go. Thanks, Lynn. That's
Sorry.
Miss Davis,
Okay.
by the way.
I'm sorry, I did not know how to unmute. Just figured it out.
Okay, thank you.
Okay.
Sure. So I think that just to wrap up our discussion of the minimum floor of jurisdiction, that and the secretary will direct this, but I mean, he did mention earlier about getting any written comments about positions on that, because I mean, the goal would be to tee that subject up for a discussion and vote early on the next thing, because the idea is to vote on these as we go along in order so that we don't just have a big list at the end and we've forgotten what the issues are.
Right.
And so that's
Marta,
the point of order, to remind people to do that.
yes, and I just want to sharpen that a little bit. Don't send me comments, or don't send Marta comments. I'd like to send policy recommendations that we could vote on. So try to phrase it or form it into a policy that would be appropriate for a vote. And we'll look at those for the next meeting.
Thank you, Secretary.
All right. Thank you. And with that, is there anything else for the good of the order before we move or entertain a motion to adjourn? Okay, well, I'll just say that I think we made progress here. Most importantly, we set the priorities, and we're teed up with one issue. We'll be ready for the next one, which will be probation at the next meeting, and we'll review once again the new revised list of priorities at that meeting. And since we had some that are very clear, Marta and Anton have plenty of stuff to research and get teed up for our upcoming meetings. Thank you all for your participation, and I will entertain any motions to adjourn.
So moved.
Seconded.
Okay, unless there are any objections. Thank you, everybody.
Thank you.
Thank you.
Thank you, Mr. Secretary.
Take care.